Our next and final guest is Dr. Richard Lamb. He is the professor of psychiatry, or was professor of psychiatry at the University of Southern California Keck School of Medicine for 30 years and is now professor emeritus. He has written extensively on a variety of subjects involving persons with serious mental illness, including deinstitutionalization, the homeless, mentally ill, community treatment, and criminalization. Dr. Lamb is on the board of directors of the Treatment Advocacy Center in Arlington, Virginia. He has consistently called attention to the need for more and better services for persons with serious mental illness. Doctor?
Thank you. I'm going to talk today about decarceration of our jails and prisons and ask the question, what will the mental health system do in that case? I should say that my co-author in preparing this presentation is Linda Weinberger of the USC Institute of Psychiatry and Law. Well, first of all, just a few words about deinstitutionalization. Prior to deinstitutionalization, that is as of 1955, there were 559,000 persons institutionalized in U.S. state mental hospitals out of a total national population of 165 million. And that works out to 339 persons per 100,000 population. The commitment of persons with serious mental illness to state hospitals was an unquestioned practice and reflected the policy of the time. The state mental hospitals accepted almost all mentally ill persons brought to them. These were institutions that could not say no. By 2010, as a result of hospital closures and bed eliminations, these numbers had dropped to a little over 43,000 for a population of over 308 million. So that brought it down to 14 persons in mental hospitals per 100,000 population, down from 339. So the 14 per 100,000 population brought us back to where we had been in 1850. With these few beds, the state mental hospitals have had to say no to the overwhelming majority of referrals that mental health professionals, the police, and various agencies and institutions now want to send to them, despite the fact that many of these persons are probably in need of 24-hour structured care. Well, to go on to criminalization, on the other hand, persons with serious mental illness who came to the attention of law enforcement for alleged infractions, who in a previous era would have been hospitalized, were now arrested and incarcerated, which is why we're all here today. Jails and prisons were now institutions that could not say no to admissions, even if the resulting incarcerated population exceeded design capacity, that is the design limits of the jails and prisons. Well, we now have a greatly increased incarcerated population, as you know. And how did that happen? Well, persons with serious mental illness were by no means the only source. Public demands to be shielded from crime, especially violent crime, as well as tough on crime politics by a sizable number of politicians, contributed to long and mandatory sentencing. The war on drugs resulted in large numbers of persons incarcerated for use, sales, and other trafficking of drugs were part of this. it would be helpful to talk about the dimensions of this greatly increased incarcerated population. In 2011, the U.S. now had the highest rate of incarcerated persons in the world. That is an incarcerated population of over 2,200,000, or 716 inmates per 100,000 population. Well, that compares to 100 to 150 per 100,000 population for Western Europe, a tremendous difference. Sentences, especially for violent crimes in the U.S., are roughly twice as long as those in the United Kingdom, 4 times longer than those in the Netherlands, 5 times longer than those in Sweden, and 5 to 10 times longer than those in France. All remarkable statistics, I think. Well, there are some factors that will probably bring change, and some of those are already beginning to be seen. First of all, the sheer number of persons who are incarcerated in the U.S. has become an expense that most state and county jurisdictions cannot afford. There's a belief by many that incarceration on such a large scale is not as effective as had been hoped. And then there was the U.S. Supreme Court decision, Brown v. Plata, that prison overcrowding is unconstitutional. This decision may well be a harbinger of change. Some other factors that may reduce incarceration have to do with a rethinking of the war on drugs, which, as you know, pretty much got out of hand, in the opinion of many. Reclassification of drug possession is one thing that is being talked about and actually happening, which would remove imprisonment as a punishment for some categories of drug possession. Increasing the use of drug courts is another part of the solution. Redirecting resources to treatment of addiction and mental illness. And I might say that some states have already done this, New Jersey, Hawaii, and there may be others that I just don't know about. Some other factors that may reduce incarceration. Changes in sentencing policy are being talked about here in California and elsewhere, which shortens disproportionately long sentences, especially for property crimes and other nonviolent crimes. And changes of states' determinate sentencing policies to reward prisoners for participating in rehabilitation programs, but allow retention of prisoners who represent a continued public safety risk. Still, some other factors have to do with, and these are things that are happening in California and elsewhere, but California certainly, creation of sentencing reform commissions to design new sentencing statutes that balance uniformity of sentencing with flexibility of individualization and allow for more judicial discretion. Adjusting the threshold value at which certain property crimes are defined as felonies to reflect inflation, that is, the monetary value of what was stolen, destroyed, etc. And such a change would reclassify crimes falling below the adjusted threshold as misdemeanors, which might mean shorter sentences or perhaps probation instead of incarceration at all. I think a good example of decarceration would be Proposition 36, which most of or many of you know here in California. This was a 2012 example of change in sentencing policy that called the the Three Strikes Law Initiative, which the voters approved 69 to 31%. So you see here in California there is support for many of these many of these policies. Now California's 1994 Three Strikes Law carried a mandatory prison sentence of 25 years to life for a third felony, but the third felony did not have to be a serious or violent crime. With Prop 36, a life sentence can only be given if the third strike offense was serious or violent, and this is already beginning to have an effect on the numbers of persons incarcerated, or in some cases, those who had been sentenced on such a third strike charge before having their sentences shortened. So again, we have an example heading in the direction of decarceration. Now, determining if there are inequities in the imprisonment of racial and ethnic minorities may well result in shorter sentences and thus a decrease of persons incarcerated. For example, the federal penalty for crack cocaine, which is more likely to be used by African Americans, was much longer than that for powdered cocaine. In 2010, Congress passed the Fair Sentencing Act, changing the 100 to 1 disparity between minimum sentences for crack and powder cocaine to 18 to 1. So you can see that would reduce sentences and people in jail and prison. Well, now to talk a little bit about Brown v. Plata, which is a highly significant event, in my opinion. In 2011, the U.S. Supreme Court, in a 5-4 ruling, and I might say the 5 were the 4 judges considered to be the liberal group plus Justice Kennedy. But in any case, in a 5-4 ruling, they upheld a lower U.S. District Court judge, three-judge panel, ruling that the constitutional rights of prisoners to adequate medical and mental health care were being violated in California prisons. Overcrowding was declared the primary cause for the violation, and the court ruled that a reduction in the prison population must occur within 2 years. Well, the court accepted a population cap of 137.5% of prison design capacity to be reached in the 2-year period. 137.5% may seem high. On the other hand, in 2005, 2006, the population of California prisons had gone over 200%. It had come down some since. But in any case, this meant a reduction in 2 years of 46,000 inmates statewide. And if you take the 16%, which is the percentage most frequently given to the percentage of persons with serious mental illness in our jails and prisons, you come up with over 7,000 persons with serious mental illness being released to the community. A significant number. Well, this left California with only 2 choices: build more prisons and increase the quality of care in this expanded system, or simply release large numbers of current prisoners as well as limit the numbers entering prison. Well, California could not realistically afford to do the former. You all know our financial state, but decided it could do the latter. And thus, prisons in California are no longer institutions that cannot say no. so that they joined the state hospitals in that regard. But there's more. In anticipation of the Supreme Court upholding this lower court ruling, the California legislature passed what is called realignment. The goal was to shift offenders from prisons to local jails. Now, part of this involves persons convicted of felony offenses punishable by incarceration for 3 years or less, with some specified exceptions, would now be placed in local jails instead of prison to serve their sentences. So there is a significant number of persons contributing to decarceration. Another part of realignment had to do with the fact that most inmates in prison are eligible for parole, but it excluded prisoners who have a current conviction for serious or violent felonies, sex offenders considered to be high risk, etc. But in any event, realignment said that these persons would now be released to their local county department of probation, no longer the state department of parole. And the law also stated that if these probationers violated their conditions of probation, but without committing a new crime, they could not be returned to prison, but could be placed in jail. So you can see that what we're coming to is the fact that before prisons could not say no, and now jails are beginning to be in that same position. So realignment results in local jails having to absorb a greater number of inmates under these new mandates, as well as housing many for longer periods of time. While many local jails were already experiencing near capacity, the requirements of realignment are forcing them to prioritize who they can serve. Thus, the jails, like the prisons, have to say no to many persons they previously could accept, including persons with serious mental illness. Well, the big question then is, if we're going to have decarceration, what will the mental health system do? Well, first of all, Brown v. Plata was limited to the state of California in terms of the Supreme Court decision. However, given the severe prison overcrowding in many other states, though I've read people saying in other states in response to this, well, our state doesn't have that overcrowding, but that may or may not be true. But in any case, there is severe overcrowding in many other states, and it's likely that mental health systems nationally will need to embark on a new era of taking responsibility for many persons with serious mental illness who were formerly incarcerated and who may present the greatest challenges in treatment. So how will mental health systems respond, and what changes in policy, practice, and ideology will result? Well, heretofore, the mental health system did not have to deal with as large a number of persons with serious mental illness, and especially those who were the most difficult and expensive to treat, because the criminal justice system absorbed many such people. Now this problem cannot be as readily resolved by the criminal justice system, and is forcing the mental health system to treat larger numbers of persons with serious mental illness. In a study in the Los Angeles County Jail in 2007, there was a study that Dave Meyer was extremely helpful in helping us get permission to do this study. We found that 3/4 of the inmates with serious mental illness required acute psychiatric care for part of their time in jail for the current offense. And this acute psychiatric treatment was actually done in the jail. The jail has one psychiatric unit, a designated unit, and they have other provisions for providing acute psychiatric care. But will the mental health system add acute psychiatric beds to provide this care for those who cannot receive it in the jails as the jails begin to decarcerate? That's a big question. Will treatment interventions that have been used sparingly or found to be controversial now be more widely embraced, as for instance, an expansion of the use of assertive community treatment? We have some. We certainly do not have nearly enough. A more widespread use of assisted outpatient treatment, known as Laura's Law at this point. An increased appreciation of the value for some persons with serious mental illness of 24-hour structured care in hospitals and intermediate care facilities, which are in California called Institutes for Mental Disease, or IMDs, and there are various forms of these in the various states. So, many persons with serious mental illness in our jails and prisons are not treatment adherent, do not seem to have the potential for rapid recovery, can appear physically threatening to treatment staff, and require extensive and costly resources which are in short supply. Does the mental health system have the capability of treating such persons? We've already heard complaints from clinicians in local community mental health clinics about the people they're getting from the state prisons, and they're just not knowing how to treat them and what to do. And if the state mental health system does not acquire the capacity to treat these persons, and if the mental health system does not acquire these capabilities, what will happen to these individuals? And that is the big question. What will the mental health system do? So, thank you.
Gentleman in the back.
Historically, the deinstitutionalization program was accompanied by proposals for something called halfway houses, which never came into existence, and I never quite understood what they were supposed to mean. I don't think they are about to come into existence now because there aren't funds for them, but I wondered if you had any comments about those original proposals and how you understood them.
Well, I think you're talking about a lot of promises that were made at the time that deinstitutionalization was being implemented. A lot of promises which were not kept. Halfway houses, all kinds of community treatment, and so forth. So,
how were the halfway houses supposed to be different from the standard issue mental health facility? Why wasn't that simply understood as a proposal to expand the existing mental health infrastructure?
Well, I can't really answer that question more specifically. I think that there were things thrown into the law at the time promising that there would be other alternative treatments for those in the community, and that was a term that was known by whoever wrote the law. Dave?
I just respond to that by noting that there is something going on in California. We'll see the extent to which it works, but there is legislation known as AB 109, about which you've heard, that covers this area. And included within it is this older concept of halfway houses. We call it step down. We've got all kind of magical words in the mental health system for these things. But it's the same concept. The other part, now, there are roughly 7,000 people to be absorbed at the community level from the state level, and as Dr. Mayberg pointed out, that shift is monumental. It's swallowing an elephant. It's not easy and seamless. It's arguably impossible, at least some people argue that. That is going on at the same time as these same individuals are being released. The 46,000 people are being released slowly but surely out of the state prisons. We do have pretty good ideas about how to deal with the population. Whether or not we have the capability and will to do it remains to be seen. But it's it's kind of deja vu all over again. We're doing what we were supposed to do 40 years ago, and we've got laws to implement it. Now let's see if we're good enough to pull it off.
Well, that's very true. There are many promises in realignment in AB 109 that there will be increased and effective community treatment, which may well just be verbiage as before. Yes.
Has anybody ever explored this concept of reclassifying schizophrenia out of psychiatry under regular medicine, back under neurology or something? Because if you, like the LPS law, if you don't understand the pros and cons of treatment, you're too cognitively impaired under the regular medicine. If you don't understand the pros and cons of treatment and the risks of refusing that treatment, you are involuntarily treated in ERs all over this nation. But under behavioral health and mental health laws, you don't get that care when you're cognitively impaired. And I've often said if my son had taken ecstasy, he would have been treated. But since he had psychosis, he was not treated. So has it ever been explored to reclassify schizophrenia, which a lot of people call a neurodevelopmental cognitive brain disorder, under a different classification of medicine to get the treatment, and then you don't, I don't know if you know where I'm going with it, just to reclassify it into medicine, where everybody else gets treatment for their diabetic comas and their, you have to stabilize somebody, you have liability and
all this is happening in the brain. I'm sorry, as neuroscience expands, why are we making any separation at all?
Right.
Everyone has a biological,
right.
So, I think it would be detrimental to pick out one or two illnesses and suddenly make them medical. They're all medical, and they're all non-medical.
But then treat them the same way then. Then treat them all the same way.
Ours just picked one because it has
Okay,
more
but
research.
be careful.
Yeah. Oh, go on, I'm sorry.
But he didn't answer my question.
I just wanted to make a comment that AB 109 is not just clearing out the prisons and releasing people to the community, but newly sentenced people under the M3 are not going to prison and they're doing time in the jail. So it really, at least the experience that we've had at Los Angeles County Jail, is the numbers of people that are staying in the jail longer has increased dramatically over the last, year and a half.
Yes, that's right. The idea is to send fewer people to state prison, and that includes persons with sentences under 3 years, and also people who have been placed under the jurisdiction of county departments of probation if they violate their probation, whereas before, when they were under the Office of Parole, they went back to state prison. Now, if they violate their terms of probation, they go to the county jail. So there are a variety of ways of trying to decrease the number of persons in prison.
But by doing that, we're increasing the number in jail. So then we're going to wind up with being probably DOJ is going to sue for having overcrowded in the jail. So what are some of the ideas, Dave? You mentioned some strategies. That would be good to hear. Like, what can be done? Are they thinking about maybe, God, an unusual thought, having a real hospital, like Camarillo, where people used to go?
We're not going to have Camarillo.
No, but I'm talking about what are thoughts? Hospital, how are you gonna get more hospital beds to people that need those beds? If the county can't afford those?
Well, I think the law as it's currently stands, and this is a rapidly changing situation, provides for people not going to state prison, which means more in the jail, which means the jails will have to begin not taking persons that they took in the past. Now, to what extent they allow the jails to become overcrowded and bring in the feds is I can't predict at this point. But presumably the jails are trying to keep down the number of persons and not get the same level of overcrowding that brought on the federal legislation. Yeah.
The question, we talk about looking at where things are successful, and you started the program with the rates in other countries, and what are they doing? Do we have this more mentally ill people in?
No.
So what are they doing that their people, they're not flooding their jails? What are they doing? Do they have higher crime?
Well, they don't have the war on drugs and the war on crime that we have had as a result of public demands for more protection.
So is there safety? Are more people being harmed in their country? No.
They would say no.
I think so.
They also don't have gun.
They don't
have guns. Because it just seems like a no-brainer that here we go, what should we do? What should we do? But yet you just showed us all these other places that have much better statistics than us.
Yeah, but they also have universal care. They also somebody gets sick, you can go to the doctor.
Well, we're going to have that eventually.
Yeah, eventually, but right now we're stuck with the old system.
Right.
I think the answer to your question is that we've covered these things in the last 2 days. So if we go back and take a look at the various presentations were made, we have seen a lot of things that will fit nicely into the AB 109 molds that we have to develop better funding sources for. We're not done doing that. We know a bunch about how to resolve the problem. One is the war on drugs. Let's just wave the white flag and move on. There are meaningful, different kinds of projects that can involve the justice system. We have to convince the justice system that it's worthwhile engaging those things and reward it for doing so. Judge Leifman has mentioned this remarkable facility that he managed to work through the political and public system to get going. That's the way in which it has to be done, piece by piece. So we've heard the ideas. We do have the resources in AB 109, in the Mental Health Services Act. More need to be generated at the legislative level. We know how to do things and how to tackle this problem. It's up to us to tackle it and do it, and it's up to us to take responsibility for seeing that it gets done.
Yeah, that's certainly a good point, because one of the possibilities is that the community mental health system will do very little, and that is what we want to avoid.
Thank you, Dick. That was great.
Thanks.
Thank you. So we are at the end of our 2 days. I just wanted to, again, give thanks to Maureen for moderating, to Chris for putting on the program, to the wonderful speakers, and for you being a great audience, and hope to see you next year.